to another episode of ComplyPlus Presents. I'm your host today, Richard Dune, and I've got my colleague, Louis Normoyle, and our guest today is George Chawawa. Welcome, George.
Yeah, welcome. Well, very well indeed. It's nice to be here, and thank you for having me.
Fantastic. Louis, how are we doing today?
Yes, all good. Nice to lose the host duties today and be more of a passive guest. So yeah, hopefully I can add some insight on this area. But yeah, looking forward to our first in-person guest with three of us here today. Yeah.
So it's the first time ever we've had three people. Yeah. So normally it's either you and I ranting at the world, or we have a guest come in and one of us talks to the guest and one is sitting outside. So Louis is our Chief Operations Officer at the Mandatory Training Group, and normally he's the host of this podcast. So the reason why we invited George today, George is going to get a chance to introduce himself properly, but there are certain things in the health and social care sector that are so specialized. You need experts to come in and talk about them. While we may have the knowledge and even the know-how of how to do some of those things, we thought it was really crucial. George's area is around data protection, GDPR, UK GDPR, so the data protection laws and practical implementation as well. Data protection is crucial because in health and social care particularly, we handle a lot of personal and sensitive data. And we've had a checkered history, really, when it comes to data protection across the NHS, the independent and private sectors, the charities. There have been quite a lot of issues. So, George, do you mind just introducing yourself, really, sort of saying, a bit of your background, how you became an expert in this area?
Yeah, absolutely. So I studied law at university, and then thereafter went to the Inns of Court School of Law in London. And then after that, I went to work in a bank. But in 2017, I found myself back into the legal fraternity, if you like, and we started to implement, the general data protection regulation, just before its enactment in the May 2018. So ever since, I have been working in that space, helping companies, particularly the corporate sector, comply with this regulation. And then, last year I decided to set up my own consultancy. So I'm on a quest really to make sure people understand this regulation or this law in a way that they can relate to. And, kind of demystify the subject itself so that, ordinary people can understand some of the legalistic jargon that is used. So it's very exciting times. I enjoy doing what I'm doing. I try to get in the mind of the legislature to say, why did he say this? What was he thinking about? And then try to convert that spirit of, what's coming out of the heart of the legislature. Yeah.
Okay, thank you. Louis, obviously, you are coming from the operations side and technology development. Having worked in the sector for over 10 years. What are your thoughts as far as, people's understanding, because you're dealing mostly with businesses, aren't you? You're dealing with key decision makers and businesses.
Yeah.
What are your thoughts regarding this area?
Yeah, I mean, I think our experience with businesses, particularly since these updated laws came in, is that, people see it as, it's basically some additional training they have to do. It's another box that they need to tick. I think the real issue is the real world examples and scenarios and the case studies, how they relate these rules to practice. But also actually considering service users and employees and staff and contractors and all those things. I think there's maybe too much focus on the service user side at times rather than also thinking about in-house. What about this data? Can this be shared? Who has access to it on different systems? So we know that now, particularly in the healthcare side, but even in adult social care, more technology and systems are coming in, but that obviously means more access to things such as data, personal or even sensitive or high-risk data. So I think for me, the understanding in practice is probably where the main gap is. A lot of people will speak to myself or other members of my team and ask, do you do training on GDPR? Do you have information governance? Does it cover Data Protection Act? But that is all being asked for to achieve a certificate to say they understand it. But for me, the real understanding is when people can apply the knowledge and be competent and be confident as well to sort of say, yeah, they're the rules, that's the law, and stand behind that. So again, it varies across organisations. It depends how serious the organisation takes this, what sort of structure it has. Do they have things like DPOs in place and other things? But my experience is there's still a huge knowledge gap in applying it.
Yeah.
And I think that's hopefully with what we're going to discuss with George today and other things we're doing as a business, we can help narrow that gap.
Yeah. So it comes back to governance, the wider governance framework, and what our take on compliance is, or it informs what we do around compliance. It's not just about training people and getting a certificate. It's not just about ticking boxes, but actually we know that generally there's a culture of box ticking in health and social care and many other sectors, to be fair. But in general, there's a culture of box ticking. Well, we've done it now, but actually, can we use it in practice?
And if something happens, what do we actually do? Because that's when people will often hide away or conveniently not be around when those things happen. Yeah.
So George, if we take it back, because obviously you are coming from legal background, then you end up working in banking. Banking, actually, there's a lot of compliance required now. It hasn't always been like that. What's your experience coming from corporate world? And obviously health and social care, we tend to then follow what's happening from corporate and we bring it in as well to try to customize it to the care industry. Right? So can you give us a bit of a background as to how that informed where you ended up, the corporate world, coming from a legal background?
Well, you touch on an issue that banks are very compliant. They are very robust because they are dealing with people's finances. So, a bank will know exactly where the money is. They've got safes where they keep a lot of money to feed the cashiers with that money. A cashier will tell you, I've got so much in 20p coins, I've got so much in 50p coins, in pounds and 10 pounds and so forth. The bank will know, the branch will know how much is in the ATM machine. So if I were to walk in an organization and I say to them, where is your data? Whether it's some of it is in files somewhere or some of it is on laptops and so forth. That diligence is actually required. Lewis mentioned about a lot of organizations focusing on the service user data. So really, you're talking about the different category or classes of individuals you have at play. Who are you dealing with? So you have your suppliers, that's one lot. Then you've got your employees, that's one lot. Then you've got your service users, that's one lot. You might even include people who do audits for you, who come to contractors, relatives of your service users and so forth. So that is very granular. You need to understand who are you collecting personal data from, because then you've got a legal responsibility to make sure that data is looked upon. You look at it, you keep it confidential. Whenever you're discussing, it's one thing to make it secure, but it's another thing is when you're using it, are you using it in a way that is confidential? So, for example, someone might leave documents on a photocopier machine. They forgot to remove them. And maybe it's to do with a disciplinary procedure that is being taken against a member of staff. That would be a breach. So I find that, coming from the corporate world, they have a reputation to protect because some of them will have shareholders. The last thing that they want to hear, the shareholder as IE, is that the company is in the press. saying that, files were found on a street or something like that. That would scare the shareholders away. So I think some of the smaller businesses we have, they may not actually fully understand the importance of making sure that data is secure and confidentiality is observed. And these laws are very complex to follow, actually. And I know most of them, but sometimes I have to refer and have discussions with the Information Commissioner's officers to say, look, let's actually talk about this. What do you think? I think this. We argue it out and we come to a conclusion. So I think it's important that people don't just do this as a tick box exercise, but to really understand what their responsibilities are. Then if they don't know, they should seek help. So come and help us because you don't know what we're doing, if that is the case. Yeah.
No, thank you for that. I think it's always interesting to look back historically where as laws evolve, because obviously after the Labour government, 97, Tony Blair's government, that's when we had Fiona Caldicott being asked to look at data within the NHS. And I remember that timeline, actually, because I joined the health and social care sector in 2000. There was a lot of talk around Caldicott, but it was mostly senior people in the NHS Trust that were talking about it. We as members of staff, I remember going to some training. But actually, it's not until 2007, 8, I think, that we started having to do information governance training. So if you take us back again to sort of say, look, 1998, Data Protection Act 1998, which then led to the Caldicott Principles and the evolution of the Caldicott Principles throughout the 2000s up to, maybe we don't go exactly up to GDPR, but that period where there was change because Data Protection Act 1998. And then in health and social care, because I want to try to bring it into health and social care, where Dame Fiona Caldicott now being asked to review information, and then she published the review in 1997 about patient identifiable information, and then it led then to the Caldicott Principles, the initial 6 Caldicott Principles. So if you can talk us through that as well, and demystify it, because I remember it being quite legalistic and thinking, but what does that have to do with me? Because I didn't feel like I was handling that sort of data in a way that we were being taught. Even the sessions were very legalistic, with somebody from the IT department coming to teach us, nurses and doctors, about information governance, and a lot of it didn't make sense. And then when you went back, you're trying to think, how do you apply this? And then you're now sort of giving each other sort of our own assumptions of how we're going to apply it. I remember it being quite a confusing time, during that period. So I don't know, what are your memories of that period?
Yeah, so essentially we were getting into a phase of digitalization, whereby people open online accounts, and that involves, putting your personal data in, and then from there you're not sure where that data ends up at. And also, particularly the NHS, which I think did a very good job, because in the NHS you are dealing with patients' data. They say that patients' data, or sensitive data, or special category data, that's what it's called now, which is health data, it goes to the core of a human being, and that it affects the psyche of patients as well, even their recovery, the way they recover, in terms of how the data is being used. And they say that it's a very intimate information as well. So I think what the Caldicott principles taught us is to really focus our minds on how important it is to look after individuals' data that has been entrusted to us. For example, one of the principles was that you must justify why you are collecting that data. Because there was a fear that organizations will start to collect data willy-nilly for other purposes. And that, I like the other principle, which is that individuals must understand their responsibilities. So I think the Data Protection Act in 1998, it tried as well as it could. I think there was a minimum fine of about £500,000. The consent wasn't well defined as it is now. And, the other thing is, the Office of the Data Protection Officer wasn't there. They did try their best to start off, to kick us off. But of course, going to 2018, when the new, GDPR Act, came in, we saw a big leap forward to make sure that, there's restrictions now. You cannot collect personal data unless certain conditions exist. So unless those gateways are there, you shouldn't be using, personal data. So if you know those principles, what you call fundamental principles, which we'll go into later on, you must really go through each and every one of them. And all of them have to stack together.
Yeah.
And then moving forward, you have the duty to, demonstrate compliance. That's what they call the accountability, principle.
Yeah.
So, for example, if the regulators walked in, they'll be asking you, show us how you comply. So you're not answering questions from them. They are not leading you by saying, do you have this in place?
They want to see
show
what
us what you have.
Yeah.
What documentation do you have? That's another addition that was made by the Data Protection Act 2018, that there must be records that are kept. And these records are living documents.
Yeah.
So every time they have to be updated.
Yeah.
And then the Office of the Data Protection Officer again.
Let's hold that thought.
Okay.
Because I know that we especially Louis, he has a few more questions that are specific from some of the providers that we were talking to.
Right.
So, so if we take it back to the operation, I'll just summarize there to say, look, 1998, the focus was on protecting individuals' privacy by regulating the processing of their personal data.
That's right.
I think this is a time where we're all opening email accounts and starting to go online.
Yes.
And somebody, a civil servant, has left a laptop on the train, and it's got 500,000 names. Which officer knows that? So it applied to both manual and electronic records of personal data. Then how we learned about that now, I was still working in the NHS at the time. I was a nurse at the time. And we had to justify the purpose of collecting data. And you had to use it only when necessary. Remember, we're also now using computers. So people were checking records of their friends and relatives. And then I remember people being disciplined for that. You couldn't even check your own blood results on the systems. Right? And use the minimum necessary.
Exactly.
I don't need to know your whole life. Obviously, when I'm doing an assessment with a patient, I'm meeting them, I ask them a lot of questions and ancillary questions that help me put their social sort of background in, it is part of their treatment. And as you rightly say, you surrender your data when you're talking to your GP or when you end up in A&E because you want treatment, and treatment depends on you being open and honest with your data. But you are hoping that these people will handle that data confidentially as well. Then access on a need-to-know basis.
That's good.
If you're not involved in the person's care, then you shouldn't access this data. You have no business asking for this data, right? Even if you work in the same hospital or the same department. Then awareness of responsibilities. For the first time now, healthcare workers were now being asked to show that they are responsible, and people were being disciplined. Some people lost jobs. Some departmental managers were in trouble as well for not having robust systems at the time. And then compliance with the law, Data Protection Act, and then the Caldicott principles, obviously, to top that up. Then we started talking about the duty to share. Because if you think about safeguarding with the Victoria Klimbe case, with Baby P, with so many difficult safeguarding cases, and now actually the point was there are so many organizations that held pockets of information and they were not sharing between different agencies, different providers. And now there was a duty to share.
Right.
So people may consent to their data being used a certain way, but sometimes actually if there's a duty to share, that duty comes top and first.
Can override the consent. The fact that there's no consent.
And that can be quite confusing. I don't know what your take is on that, because it's quite legalistic. You sort of think, hang on, so should I share? Should I not share? Do I end up in trouble? What if somebody calls and they're asking for this data? Many people made a lot of mistakes because there was a lot of confusion at the time. So I don't know what your take is on that. Obviously, now, even the Caldicott principles, there's the extension of informing patients about information use, and people can request the information. But during that period, do you see the confusion where I was a frontline worker and how I found it really challenging? And my colleagues were feeling the same.
Yeah, I think you're quite right. It can be, a very huge information to take in. And, this is where the training has to be robust. And people are allowed to ask questions if they don't understand what is being said. One of the things that you touched on is data minimization, which is collect the data that is necessary for the purposes of which you want to use it for. Otherwise you can end up going what is called on a fishing expedition, talking things that are outside what you really need. And then you touch something there on you're not allowed to access information that has got nothing to do with you. So there is actually a case in the press where I think it was the medical secretary somewhere in the country, and they started to look for data of their neighbors. In a GP, they worked in a GP practice. So, I just want to find out what my neighbors, what issues are they facing and so forth. And unfortunately, they were found out. And then it ended up as a police case because you're not allowed then, from a criminal point of view as well, to access information that you have no right to. That's an offense in itself, apart from obviously, infringing, GDPR. So I think the question that we're asking is to do with the multi-agency protocol, where a number of organizations, the police, I think it's the social services,
local authorities.
And they need to work together in order to build a picture on what's happening to a particular individual. So the fact that, this is my belief anyway, that the fact that they were then asked to work together, otherwise information will slip through the gaps. Let's have a bigger picture. Let's share information. So multi-agency protocol, so that nobody receives a short service, if you like. So I think there's legislation now in that, in that particular scenario, which then overrides an individual's, position to say, I don't want my data to be shared with so and so. So I think they'll be told up front. That's my belief.
We've got responsibilities under the CARE Act. And obviously then when you look at UK GDPR, Data Protection Act 2018, there are provisions for that now. So it's around that building professional practice and multi-agency working so that we don't shortchange people. Because quite often when you do a root cause analysis after the fact, you find that this agency or that department had information that was not shared. So it's crucial. It's better. Things are definitely better. If I go back to 2006, 2007, 2008, it was really challenging. And I think events were now deluging the system. It's not like things were not happening. Things were happening all along. But because now the press was catching up to it. And the press was exposing some of the failings. And then there was a lot of pressure on NHS trusts. It was primarily NHS trusts. Now even care homes have to do it. Domiciliary care companies. Everyone has to do it now if you're handling personal and sensitive data, which is really crucial. Louis, we started working together, I think, around 2012. And you have seen the evolution, even what led then to UK GDPR. In fact, GDPR in general, it was European guidelines, isn't it? Then we ended up with Brexit, and then we ended up with UK GDPR, Data Protection Act 2018. How is your experience dealing with providers? And even also the technology, developing the technology and ensuring that the data that we handle is safe and secure, and also we treat it in the same manner. We now had to register with the ICO. We now had to get a DPO to come into our organization as well.
Our business, I mean, I think from the client perspective, first of all, again, confusion, and then obviously Brexit on top of it really just caused even more confusion. And then, like you say, you've had the founding of UK GDPR, and I think, like I say, a lot of people get a bit mixed up about which one's which things do they need to understand, which bits are maybe not too relevant for them. But I think it's also like you say, the governance framework is where a lot of particularly the smaller businesses, are failing because they're not really aware of what systems, what they're inputting into these systems in terms of data. Who may then have access? Does this member of staff actually have the same access? Because even with things like permission sets, you realise that when anytime you bring any new software or digital system into a business, you have to do risk assessments for the data. You have to be really aware on who actually needs access. As George was saying, do they have the information they need only, or have they got more information than they actually need or even are allowed to have? So I think a lot of our clients would still benefit, I feel, from having that level of understanding and almost having some of these toolkits available to sort of say, look, if we're bringing software in, which obviously our sector, health and social care, is trying to do that now, even the government are sort of pushing for it and pioneering for it, really. So, but actually when you bring that in, yes, it might be there to solve a problem, but have you actually done that full risk assessment? Have you done that needs analysis? And is it set up properly? Because it only takes one, as you said earlier, one bit of a USB or a laptop left on the side. It only takes one person to have access to the wrong bit of information. And the sort of chaos it can cause on the back of that could be monumental. Like we were saying about, they become criminal cases. There can be huge fines. The business can even be under scrutiny then as well. So I think that's my experience from the client side. Again, there's still a tick box mentality, but I still think people don't always put maybe the seriousness to this area because they almost think this won't happen to us.
Yeah.
This isn't going to happen to us. Oh, did you hear about that care home down the road? Did you hear about that NHS trust? That won't happen to us. But that sort of mindset, it will end up happening to you eventually, especially with the rise in some of the cyber attacks we're seeing across the world. We saw about the cases with M&S and some of the biggest companies. So if you think as a small company it won't happen to you, if they can do it to some of the best funded companies in the world, it can happen to anyone. And I think from our side of the business, we've had to change a lot of things. We had to get DPOs in. We've had
data protection officer.
Data protection officer for listeners who might not be familiar with the term. But even us, we're a high systems business. We're a software company now, so we've got lots of different systems. We also have teams in different parts of the world, so you have to sign different sort of contracts with them. You have to have your standard contractual clauses. There's a lot of different considerations. So I think even from our side, we've had to really learn this area and understand what to do, even going through the Cyber Essentials process that we went through earlier this year. Those questionnaires you get sent are really challenging, and they really make you think about each little part of your business. What devices are people using? What systems do they have access to? What data are we holding about some of the people in our business? What data are we holding about our clients? It's a journey, but then once you've got a system set up and it's maintained, you highly reduce that risk. You can never say nothing will ever happen because you never obviously know what's around the corner. It's a worthwhile exercise. And there are a lot of other schemes out there like the IESME frameworks, the Cyber Essentials, which can really help support this area because it's highly relatable to data protection. Yeah.
Okay, thank you, Liz. So, George, I'm going to go into GDPR now. So, in its simplest terms, when you think when we're talking about European general data protection regulations, they were part of the European package, wasn't it? Then we had Brexit, and then we ended up with Data Protection Act 2018, UK GDPR. In simplest terms, can you explain to our listeners actually what that is? GDPR, Data Protection Act. Why did we need it?
I think, bear in mind that the country had been in Europe, I think, from 1973. So with the rise of digitalization, mass data centers, and the trade aspect, a lot of information was crossing borders from Europe into UK, from UK into Europe. So there was if countries had different laws governing, personal data, how personal data is managed, that caused confusion. So, we became, part of the European General Data Protection Regulation because we were now uniform with other organizations. And in fact, that model has been taken worldwide. I think in South Africa, they've got also their own version, but it's still called General Data Protection Regulation. Now, so we were part of that, and all of it, it was enacted in this country by the Data Protection Act 2018.
Post-Brexit.
Exactly. So it was uniform with Europe, so that the trade could be affected very easily because you were sharing individuals' data. Now the country, the UK, came out of Europe, Brexit. I think it was in 2000 or thereabouts. So the framework at that time was the same, okay? But it was called the UK GDPR because there was foresight that in future, the UK might decide to enact certain provisions away from Europe according to how, the business particularly were responding to this particular act. Because one of the things that the businesses were saying is there were certain types of documentation which was a bit onerous on them and whether it could be done away with. So I think as we speak right now, so we've got a new act, the Data Usage and Access Act 2025. Yeah. Now we are beginning to see a shift slightly away from the European GDPR, which we came out of at Brexit. So one of the things that organizations out of there will be required to do is that individuals have got a right to complain now. And that complaint must be acknowledged by an organization within 30 days and must be dealt with, as without undue delay.
So much like a complaints procedure,
if
you have a complaints policy.
Yes. Yeah. So it means that now organizations have to think about a complaints policy and procedure.
In relation to
yes, because people can now complain. Yeah. And it's another gateway for people to write, if they are dissatisfied about something, they will complain. So I think, this is where now an organization, which is a learning organization, will be thinking, okay, what do we need to do? Because I can tell you that I'm sure that it's not been expressed as such, but I'm sure if an organization is not able to respond substantially and with knowledge to a complaint, that can be taken forward. And
so it goes to ICO then?
Yeah, I want to believe that. And if you try to, brush off a complaint, and the person then takes it further, if they find out that actually you don't know what you're talking about by the way you've responded, that could expose an organization. Okay? I'm not saying definitely this will happen, but I can foresee that it's likely to happen.
It's actually happening already with the Care Quality Commission.
Yeah.
Where even when people are whistleblowing, they can go straight to the CQC hotline. But then the first question is, have you raised a concern with the organization? Depending on the nature of the concern, obviously. Yeah. But you always want to start with the organization.
Yeah.
Then actually, you still need to report to the Care Quality Commission anyway. And as part of their inspection is to check those safeguarding concerns. So I imagine ICO is probably becoming a bulldog that actually has teeth, because maybe initially they were set up just to be dealing with UK GDPR at the time, but now maybe actually with the new act, we're now starting to see a toothless bulldog actually starting to have teeth, and actually organizations now being required to be accountable. Is that the case then?
Yeah, I mean, I think when we first started, when the Data Protection Act was enacted, and with GDPR then, I remember there was an incident somewhere, and we asked the ICO, okay, this has been a small incident. What if something happened again? And at that time they said, we'll have tabs on you, which means so. I foresee a situation where an organization, for some reason, is receiving a lot of complaints from either members of staff or from the service users, that can then be escalated, in my view, to the ICO. So could that be then a trigger for them to say, hang on, let's just go and see what's happening in this sector? Because they can take that approach to say they may not necessarily, focus on one organization, but if there's a pattern that affects a certain community of, data collectors, then surely what stops them to say, no, we need to look at this area, whichever, sector you're talking about, as a general, inquiry to find out what actually is going on. Because they're there to really safeguard that, personal data is used legally and lawfully.
Yeah.
And understand. So yeah, I think it's an area to watch out for, and make sure that you've got your things in place, and that you want to do a thorough job in that area when somebody is alarmed by the way you're using their personal data.
So we've used the term a lot: personal data, sensitive data. What exactly are they in simple terms?
So it's a very good question. Personal data is basically things like your name, your date of birth, your passport number, your driver's license number.
So things that identify you as a person.
Exactly. Some of them can directly identify you. For example, your passport. People can see who you are. Some of them, you can identify a person if you take one piece there and one piece there. A typical example is your number plate. I may not know who you are, but there's ways to find out by accessing other records, and then we can piece those things together. But basically, it's personally identifiable information. That says, who are you? Your name, your address. One of the things that we find in certain pharmacies is where you are waiting to collect your prescription, and they say, "Are you Mr. So-and-so?" in front of everyone.
Yeah, I get people. Are you so-and-so? Then are you still? And then they say your address, and they think, oh, they need training. My GP practice needs training.
Shouting it across the room.
What's your date of birth again?
Yeah,
and you're trying to whisper your date of birth.
And then we come to this
sensitive data.
Yeah, special category data. This is data that requires, if you like, greater protection, because if it's loosely used, it can affect somebody's rights and freedoms. Yeah. So one of which is your patient data. So
medical records.
Exactly, medical records. So you've got I think there's a case in a certain country where the courier was sent with medicine to deliver to a young lady, but the diagnosis and what the medicine was for was actually there. So you are exposing somebody's personal information and their health data to somebody else. So as we said before, health data goes to the core of a human being. It can affect their psyche and recovery if it's not handled properly. Some of it is concerning whether you are a member of a trade union, for example, because some people may be against certain thoughts and so forth. Some may be to do with your race. Again, this is also, it should be protected because it can have consequences, where if it's not handled very well. So those are some of the examples. So the special category data, that's what it's called now. It was formerly called sensitive data. Yeah. It requires a higher degree of protection. I think
it goes into the Territory of Human Rights Act, Territory of Equality Act.
Exactly. Yeah. Your freedoms, your right not to be discriminated because your collection about your ethnicity has been lost or has been collected unnecessarily.
Religious beliefs.
Your religious beliefs, for example, someone may not agree with your religion, or sexual orientation, for example. So it covers a range of things, but there we are saying it requires a higher level of protection because if it is not protected, it has consequences on your rights and freedoms,
So in continuing with that sort of thought, what is a data controller? What is a data processor? Because when Louis particularly is having conversations, he's using these terms, and you realize actually many people don't know what that means. Although they have signed up with ICO, they've got the paper to prove it, they don't know the difference between a data controller and a data processor, and they don't know whether they're a data controller or a data processor. So these very simple terms, what do they mean, these phrases?
So basically, a data controller is one who knows the purposes for which they are collecting the data for. So, for example, a school where my child goes to, they want to know, the child's father, mom, address, and so forth. They need it. They know the purpose for which they're collecting, and it's collected by them from the data subject. So this is the person who is providing the data. And the school will tell you, well, we need to know who the child is. We need to know who the parents are in case of there is an incident or something like that. So they have a reason to collect that data. And that reason must be noted. Okay? We're going to go back to the Caldicott principles that you must have legitimate reason for collecting people's data. Yeah. Now, a data processor is, for example, an organization which wants to outsource the payroll system to another company. So they don't have enough know-how and manpower to do that themselves. Please, can you manage the payroll for our staff members? So they'll provide the names of the staff members, and the payroll company will then sort out how much tax they should pay, national insurance, that kind of thing.
They're providing a service.
Exactly. They are providing a service to the data controller. So they are acting on the instructions by the data controller. The data does not belong to them. It belongs to the data controller. So they will have a document which will be very granular, setting out, the reasons why the data is entrusted to them, what they need to do to protect that data. So it's a document they have to sign because the data does not belong to them. They are merely processing that data. So that is the difference between a data controller who is controlling the data, collects the data, knows why he's collecting the data, okay? But then he might want certain people to help him with something else. So that's where he then say, okay, can you help me to do X, Y, and Z? So that person, like the payroll company, will be processing the personal data for specific purposes as outlined by the data controller.
Yeah.
You see.
Can you be both a controller and a processor? And is it still important to have distinctions within your organization if you are both?
Yeah, well, I think it's very important. I don't know how you can be both a data controller and a data processor, unless, for example, let's take the point of outsourcing your payroll system. So if you are a health provider, health service provider, and also you are paying your members of staff, you're still collecting the data. So where the difference is the purposes for which you are using the data for different categories. For my service users is to provide medical service. For my employees is to make sure I pay them. But you remain the data controller, not a data processor. So, the two normally are very distinct. You can do different functions, but you still are the data. If you're asking, for example, you are paying your members of staff, you are managing the payroll, you say, well, I'm collecting the data in order to pay them. I collect it and I pay them. Nobody else is in between us. The same applies to my service users. I collect it and I provide the medical assistance that I need to. So you are just a data controller.
Okay, makes sense.
It is only when you pass that data to somebody else who's got nothing to do with it, on condition that they are there for legitimate reasons, by the way. So you can't just pass information to somebody else. No. That will not be allowed. So you must have legitimate reasons, number one. Number two, there must be a covenants. We call them covenants, which means very granular statements to say, keep this data safe, make sure it's secure, etc., etc.
Then you check their systems as well to ensure they have to be satisfied that they've got the right systems to...
Because if I was in that position, you're absolutely right. I would want to know whether these systems are safe. Because guess what? If that data processor is compromised in terms of the data you've given them, the primary responsibility comes back to you.
We've seen that. The reason why we're asking you, we've seen that many a time. And then all of a sudden, it's when things go wrong that people start thinking, hang on, am I the processor? Am I the... Then they have absolutely no idea because they never thought about it when they designed these processes. But actually, that's what GDPR is asking us to do, isn't it? So even when we design IT systems, manual processes, think about how the data is going to be collected. How is it going to be secured? And if you have an external provider for HR services or payroll, the covenants, you know, what the agreements in place. And due diligence to check that they have the right systems. If they have servers, where are those servers sitting? Are they in Brazil? Are they in India? Actually, you know, those little things, actually, people have not thought about that at all.
Absolutely. I agree with you. If I was in that position where I was collecting data, I was a data controller. If I was in that position, and I just want to highlight that and actually say, if I was in that position, I'm collecting individuals' data, I want to hand it over to somebody else to process it for me for legitimate reasons. And I don't understand anything about their IT systems. I would come and get you and say, you know what, Richard, I am entrusting them with my client's personal data. Can you please go and examine, audit their systems? Because the buck stops with me. That's why I would do that. For somebody who knows what they're doing, to go and make sure that data is safe, away from the agreement that we have, because after all, it's only a piece of paper. I want to go further than that, to make sure practically somebody who knows what they're doing, they've checked whether the client, so the information I've given to other individuals is going to be safe.
Okay, fantastic. Thank you. Luis, I don't know from your side, any other thoughts?
No, I think some of these terms, as I say, they're quite important to understand that distinction between controller and processor. And I think the way you explained it, hopefully a lot of our listeners will find quite useful, because I think you've managed to sort of put it in sort of layman's terms, as they say. But again, a lot of these things are covered in the training. And again, when you relate it back, it's, again, seriousness. How serious are we taking the training? Can we apply it? Can we, you know, if we're to do a test at the end of a training, do we actually know what these terms mean? But again, putting it in to practice, and I think the way you've explained it there is a lot easier for people to probably comprehend, you know, the difference between them. Can you be both? What are some examples, like the example you gave about the outsourcing payroll? I think hopefully a lot of our listeners will find that interesting. So yeah, look, there's a lot of different terms in this area. I know we're obviously trying to focus on sort of the key and most relevant ones today. People just knowing those definitions, it will help them when they get asked questions by auditors, when things go wrong. If they can demonstrate that understanding, as you say, it will go a long way for them.
So, data protection officer. Who is a data protection officer? Does every organization need one? We're talking maybe mainly about health and social care organizations here. What about data protection officers? Do I need one?
Yeah, so I think there is somewhere where I've read that even if you don't think you need one, the regulator would advise that, you know, it's good practice actually to have one. Okay. Because normally, one would want to appoint a data protection officer where they're dealing with huge volumes of data, high-risk data. But actually, you lose nothing by actually saying, you know what, I think, we may not be handling as much, volumes of data, but still we want somebody who knows what they're doing and who knows what we should be doing.
So especially when you're handling special category data.
Absolutely. Yeah. Absolutely. It shows how serious you are by understanding that, you know what, I need a dedicated resource to just look at this. So that person will be responsible for making sure there are policies there, making sure that members of staff are trained, making sure that, the different departments, if you've got departments, they'll do an audit to say, okay, you've been trained and you know what you're doing. Let me test you. So this is internal.
So it's an internal audit as well, isn't it?
It's an internal check. And whatever the results, if they are doing their job properly, whatever the results they find, they should be documented. It's part of your documentation now to say you take this issue seriously. So if the regulator walks in and you will say to the data protection officer, show us the documents. And he will say, yeah, I did an audit after the members of staff were trained to see how much they retained, and I found that many of them scored 30%, right? It's there. Yeah. It shows that, and then what did you do about it?
Now.
We said, no, they need some thorough training follow-up, or we need to test them, okay? Then the other thing is, he is supposed to be independent. So, in other words, he's saying, well, if you do something wrong, I'll tell you, okay? So, again, he might think, okay, I think this has happened. We need to self-report. If it doesn't meet, doesn't meet a certain threshold. What you want is just somebody who is objective.
Yes.
To make sure you are doing the right thing. So it's not about we have got somebody there and they kind of, look over what has been done wrong. No, it's actually somebody who says, have you done a risk assessment? Where is it? You can ask them questions because they're an expert. This is what we are going to do. He will also advise you to say, okay, if you are doing that, you need to have a data protection impact assessment.
Yes.
Okay? And if you want me to assist you, I will do that. So there to make sure the organization is doing the right thing. And they are independent. It's just because they have told you or they found out where the mistakes are, you can't really sack them and say, well, you shouldn't have done that. They're doing their job.
That's the job, yeah.
Yeah.
So they're monitoring compliance.
Yeah.
They will conduct audits, risk assessments, and they are serving as your point of contact with ICO.
That's right.
Do they necessarily have to be a full-time employee, or can they be an outside, like you said, they need to be independent, outside contractor who then has a agreement with the business?
Yeah, I mean, there is different ways of doing this. Because an organization might say, for example, we've come together, 5 of us. We may not afford a full-time member, but if we all chip in, we've got somebody who can help us. So that individual then goes round and makes sure that you're doing the right thing. So the burden of paying from your own pocket only is not there because it's a shared, resource that you're having. So you all contribute.
Makes sense.
So I think what it does is, in my view, it's only my view, it gives organizations peace of mind that we've got somebody who's coming in, is not necessarily taking our side, but making sure we are doing the right thing.
Objectively.
If there are things that are wrong, a report is written, recommendations are put in, and organizations follow that up. To me, I think, especially in the health sector, I believe that's a very good best practice because it shows you are taking in the other thing that I forgot to tell you, Richard and Louis, is that when you're dealing with patients, they're actually vulnerable individuals. Now, they may not be like you and me to stand up for their own rights. These are people who are not feeling well. They don't have the capacity or even the energy to be dealing with this. So then, you don't put your robust systems in place, GDPR compliance in place. I'm sure the public will frown on that and say you took advantage of individuals who were not feeling well by being careless with their data because they couldn't speak for themselves.
Yeah. So it goes to governance again. How well led is your organization? When you look at CQC, they look at whether the organization is well led or not. Again, let us not forget here that we have Caldicott Guardian as well. You tend to find these in bigger organizations, but what's your take on the idea of the Caldicott Guardian and requirement, but also how does it differ from the DPO?
I think that's a good question, actually. I want to believe that the Caldicott Guardian is really to, if you like, to be the gap between the provider and the patients. In the interest of the patients.
So patient safety, safeguarding,
that kind of things. And I think it's a good office to have, actually. While the DPO probably might be looking at just making sure compliance with the regulation, but this one is really concerned about, the well-being of the patients. That's my view on that point. And I think having that office actually is another way to demonstrate how serious you are about making sure you are treating these patients fairly as far as the law is concerned, because there's somebody overlooking and making sure that it's being done in the interest of the patients.
Yeah, so they know the organization very well. They're a senior member of the team.
Yeah.
And then they are the named person within the organization to make sure that the safeguards are implemented and the systems are working.
Yeah.
But they also collaborate with the DPO.
Exactly.
And then both roles are very critical in that sense. Then.
Yeah, absolutely.
Makes sense.
Yeah. I think it just goes back to show us again how important it is, a patient's data is. And do you know that even politicians have tried to access their opponents' personal data with a view to get one over them? I know there was an election somewhere where a member, one candidate was saying, well, I have been looked through by my GP. Have you gone to your GP trying to force the other person to...
Well, did Donald Trump end up publicizing his own health records? And this doctor says he's very, very fit for a 79-year-old. Compared with Joe Biden, I mean, politicians, it's a good thing that, we have different regulations for organizations.
Yeah, so that's how powerful, health data is. People can find out information about people to discredit them. You see. So, because it is very private data, if you like. I know it's special category data, but it's very private. So if you really want to expose someone, so that's how important I think in this sector, that people take their responsibilities very seriously. Because the one small thing can really have a huge negative impact on the organization.
Okay, thank you. No, I really appreciate it,
So I suppose the last sort of thing on this would be, if no one's taken responsibility, what are organisations putting at risk? What are the potential consequences?
Right. So if people are not really demonstrating their accountability responsibilities, what they're doing is putting themselves, to the risk of a financial penalty. Which, the maximum now is £17.5 million, or 4% of their global turnover of an organization. That's huge.
Turnover, not profit.
Yeah. So that's quite huge. And then they can be reprimanded. I know one local authority which was always late in responding to subject access requests. And the ICO actually said that this is systematically being late in responding to subject access requests. So again, if members of the public see that information on the website, in that locality, it leads to other discredit of that organization. Then you can be investigated, which means that, the regulator might come in and say, you know what, we've heard so much, it's in the press, this has happened, you've lost people's data. We've now come to see where you are at with your responsibilities, GDPR responsibilities. But there's also reputational risk. This is very feared, particularly in the corporate sector. People are very afraid to be named and shamed because they've not protected, personal data belonging to their clients. So I think it shows how serious personal data is. Very critical. Any business would love to have everybody's names, because what you do is then you can profile people, the ages and so forth and so forth. So it can be monetized. But also we see that it's aligned to people's rights, freedoms and rights. So, and it's a fundamental right to your, right to privacy. It is a fundamental right, which means that it's really core, it's very important. So I think I'm repeating these things so that organizations, those who are running organizations, can see how serious this is, to make sure that, they understand the consequences, and that, sometimes it can lead to devastating outcomes. Yeah.
No, it's important. When you talk about governance and compliance, you've gone to university and trained as a lawyer, then you did postgraduate qualifications. You worked in the corporate world. For you to come and sit here and talk confidently is because you've lived this. But obviously, somebody setting up a company, they're very good at delivering care, but they're very reckless with data. Then their governance framework is failing. And I think it's important. That's why it's important for us to have people like you here to discuss these issues, because We see it in the sector day to day. So if I'm to summarize very quickly in simple English what we've talked about, you've defined the key terms really well, and you have also emphasized the importance of data protection policies and procedures that are aligned with the laws and the regulations and best practice. The spirit, you talked about the spirit of the law, not just the letter. So it's not enough to just have a document and an ICO document. You need to actually know what it means, know your responsibilities. You talked about the importance of training staff regularly, learning from mistakes and using them to improve services, setting up breach response processes within the organizations. So ideally, you want an external data protection officer working with your internal Caldicott guardian to do that and regularly audit those systems. And when something happens, you review them again. Complete the DPIs when introducing new systems. So risk assessments, whenever you're introducing a new system, whenever you're bringing in new contractors or new partners, do your risk assessment. Whenever you are outsourcing work, do your risk assessment and your due diligence. You also talked about the importance of internal audits. So that could be led by the Caldicott guardian. They could work alongside DPOs from outside. Appoint or outsource to a DPO. You are saying that special category data, which is basically all of health and social care, should really have an external data protection officer in addition to their internal processes. That's good practice, but it also shows their seriousness in taking their responsibility seriously. And finally, you also talked about what could happen if we don't do these things. People could lose their businesses, £17.5 million, or 4% of your global turnover. Many companies in the health and social care sector cannot survive after such a fine, and some have actually gone out of business because of that. And finally, document everything. Even when things are going wrong, document them. And then show what you have done. Because if it's not written down in health and social care, even in law, you say it didn't happen. So I don't know if I've done that justice to summarize what we've discussed today. I don't know if you have anything else to add there.
I think you've done a very good job in summarizing there. Some of the things I've said there are my personal opinions because I've worked in this sector and I have strong beliefs in that certain actions should be taken. One of the things that we must remember is that, and this happens a lot, so a person asks for their information, either it's withheld or people change what they've written down. Okay, because for fear now that the person is going to know what we had said about them. So be very careful what you're writing about people. Because
even employees, there is a tribunal. So let's come in tribunals.
Because they can ask for their personal information. So if this is now based on your opinion, that could be a problem. And then there might be a temptation to alter that information. That becomes a criminal offense because you're now trying to,
forgery.
Exactly.
Forgery.
You're trying to avoid exposing yourself. So you now manipulate that information. And nobody wants a criminal record because it affects so many things on an individual, particularly if it's to do with dishonesty, because it could be, for example, a person is asked for their information and there's a time frame for which you need to deal with it. And you were late, but you altered the stamp. So, actually, we sent it on this day. If it is found out, then that's really...
criminal
I thought I would just...
thank you. Thank you for that. Louis, I don't know whether there's anything from your side just to add as we wrap up?
Not necessarily, no. I think hopefully we've covered a lot of the basics today. We've gave obviously some, I think, really useful examples and relatable examples for some of you that will be tuning into this. And I suppose, like I say, the next steps now are looking on implementing some of these things in practice, going back to some of the key areas we've discussed and almost analysing your own organisation and doing a health check in your own mind to sort of say, do we have this? Do we understand that? What systems are we using? Are we due an audit on these systems? Have we done a necessary risk assessment? And so on and so forth. Obviously, these things take time. We obviously ran a webinar last night on one of the biggest bugbearers among sort of senior people in health and social care businesses. This all sounds great, Richard and Lewis, but when am I getting the time? Even when you're giving them the tips on how to actually do it. But look, these things, as George has explained, you do need to make time. You do need to have the right people in the business. And and it is a very serious issue. And I think, like I say, things like what happened to M&S and stuff earlier this year, they're very real world cases, and the cost and the damage that these things can do to your business if they're not looked after properly are monumental. So yeah, I'd say, some of the next steps we're going to look at with George are sort of looking at what good looks like in terms of in practice. We'll have some checklists. We'll have some more insight from George later down the line. We're also going to have a page on our website which will include George's profile. So if you do want to get in touch with George or find out a bit more about some of the services he provides from a DPO perspective, from an auditing perspective, you'll be able to find his information there. We'll also put his LinkedIn profile in the comments once this video goes out. Yeah, so yeah, that'll be it from me. And thanks a lot for joining us today, George. Yeah,
thank you.
Thank you, George. You made a tricky topic so much more relatable and simplified. And I'm glad. Look, the first sort of approach to this is simplifying things.
Yeah.
And then we can go into more detail in future podcasts and webinars. But also, even our existing clients as well, we're going to let them know that George is around to help them with those risk assessments, the audits, and also full consultancy service and DPO service. Because I know a lot of health and social care organizations don't have a DPO. And when I've asked business owners who are very astute, actually, they didn't know what they didn't know. And I hope that what we've discussed with George today has laid bare some of the risks, actually, that your business can end up with. And we can't afford to pay £17.5 million or 4% of our global revenues with the sector the way it is right now. We need to take responsibility seriously as far as data protection, Caldicott principles, having Caldicott guardians, and also having data protection officers available to support us. Thank you very much for joining us. We'll see you next time.
Thank you.